Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 90. In this podcast we are going to be taking a look at three recent cases, and the first, it's an EAT case dealing with claims of age discrimination and unlawful deduction from wages in relation to a benefits package offered to an employee under the employer's disability plan. The appeal was concerned with the contractual construction of the disability plan and whether the tribunal had erred in failing to consider whether her contractual entitlement had been varied following legislative changes to the statutory retirement age. But I think it raises wider issues than that, and that's what we're going to be talking about. Secondly, another EAT decision, but this one's in relation to childcare vouchers, and in particular the EAT considers whether it was discriminatory for an employer to make it a condition of entry into the childcare voucher scheme that employers had to agree that such vouchers would be suspended during any period of maternity leave. Although the case has had a lot of significance, I think it may be less significance than the publicity might have you believe. And finally, we've got a Court of Appeal case that looks at a High Court's decision to increase an employee's commission level in circumstances where the employer did not provide evidence of its decision-making process in the way it had allocated commission to employees. Based on the discussion that we had here in the employment group at Mayor Brown, I think I'm in a minority in thinking this is a significant case, but hey, it's my podcast, so I get the deciding vote. Don't forget, as always, the podcast is available via iTunes and YouTube and the Mayor Brown website, of course. The YouTube version has case names as part of the episode, and if you follow me on Twitter, then links to the cases we're discussing are posted out when the podcast is posted itself. So first case, Smith and Gartner UK Limited. This is the EAT decision, which looks at whether a tribunal had erred in striking out an employee's claims for unauthorised deduction of wages and direct age discrimination in relation to the provision of a benefits package. Background facts, Ms Smith, the claimant, had been employed by Gartner UK Limited and in 1996 was offered a benefits package termed by her employer as including a disability plan. The plan included, amongst other things, PHI, life assurance, company sick pay and income protection insurance. The income protection insurance provided 75% of salary until the employee either returned to work, retired or died. The insurance was stipulated to be subject to the employee's terms and conditions of employment, and at the time the disability plan was introduced, Ms Smith's retirement age was 60. Pausing there for a second, it's important to note, of course, that at that point there were no rules on age discrimination, 1996, so this was an entirely legitimate retirement age. The employer also had in place an accompanying benefits guide, which expressly stated that all benefits offered were subject to the law in force at the time and that the employer reserved the right to terminate or offer alternative benefits as it considers appropriate. 2002, Ms Smith goes off sick and starts receiving PHI benefits, and she doesn't return to work. She remains absent by reason of her illness up to the point of this litigation. In 2007, by which time she's been off for 5 years, Gartner emailed all of its employees confirming that due to the legislative changes, the age limits for claiming benefits under its income protection insurance would change to accord with the new retirement age of 65. However, in 2014, Ms Smith was informed by Gartner that her benefits would cease when she got to 60, despite her remaining an employee beyond that age, as she was only covered by the scheme insurance provider until age 60. So, Ms Smith brings claims to the tribunal for unlawful deductions from wages because she had claimed she had a continuing contractual right to receive PHI benefits until her retirement at 65, and she also claimed direct age discrimination on the basis that Gartner had treated her less favourably because of her age by not continuing the PHI benefits, and that such treatment could not be a proportionate means of achieving a legitimate aim. The Employment Tribunal struck out her claims. It didn't even get to a substantive hearing, concluding they had no reasonable prospects of success. This is on the grounds that Gartner, it said, was bound by the terms and conditions of the insurance scheme, applicable at the date on which Ms Smith first started claiming income protection. Those terms provided that payment would cease at the age of 60. Gartner's benefits guide also stated the benefits it offered were subject to the rules in force at the time, which also provided for payment to cease at age 60. Further, the tribunal considered that even if the benefits guide was contractual, it only provided that Gartner would take out insurance, not that it would make any payments to Miss Smith. The tribunal therefore concluded that the treatment of Miss Smith was not because of her age, but because of the terms and conditions of the scheme and the employer's benefits guide. Consequently, it struck out her claims as having no reasonable prospect of success. Well, not surprisingly, Miss Smith goes, not so sure about this, and goes to the AT. And she said the tribunal had erred in determining her retirement age for the purpose of benefits was 60, and that the 2007 Gartner email hadn't varied her contract. The EAT dismissed the appeal, however, and they decided that Gartner's contractual obligations under the disability plan were limited to providing insurance. They did not cover making payments to employees under that plan. That was for the insurers. The EAT concluded that Gartner had complied fully with its contractual obligation, take out insurance, pay what the insurers pay it, and that the cessation of benefits to Miss Smith at the point she got to 60 was in accordance with the rules of the scheme at the relevant time, i.e. the time when she'd first started to claim under the scheme. The EAT did not consider the 2007 note circulated to employees. They didn't consider that was a contractual change, entitling her to insurance benefits up to age 65. Instead, it held that close analysis of the documentation the employee is relying on is necessary to conclude the extent of an employer's liability to pay or provide PHI. Here, the EAT held that the benefits guide referred to insurance made it evident that Gartner was committing to providing a policy and was not obliged to put cover in place by its own payments. So, as such, the EAT said that the obligation was to put the insurance in place, not to pay the PHI itself. In relation to whether the 2007 email was a variation of contract, the EAT's reasoning is interesting. The tribunal hadn't seen the 2007 email when striking out Ms. Smith's claims, but the EAT considered that the email was too general in terms to assist the claimant in establishing a, quote, real-world case of variation, unquote. The EAT took into consideration the email had been sent to Gartner employees across the board, was not specifically directed to her. It also considered that she was in an unusual position because she was already in receipt of benefits under the insurance policy at the time the email was sent, and therefore the EAT held that those benefits were subject to the rules in place at the time she entered the scheme. Equally, the change in policy provider which had happened didn't vary the contract, as the policy had not changed and its rules remained the same. It was just a different insurer that was meeting the liability. On that basis, given the terms of the policy were the insurer's terms and not Gartner's, and that the terms were the cause of the discrimination, allegedly, the EAT said it followed that the cessation of payments to Ms. Smith could not be discriminatory. Further, Ms. Smith could not qualify for the new PHI policy as she was already claiming under the previous policy, meaning she didn't meet the conditions of the new scheme that had then subsequently been put in place, covering people up to age 65. For those reasons, the EAT dismissed Ms. Smith's appeal. Well, I want to put this case in both for the general comments it makes and some of its limitations. First, in relation around the comments around the interpretation of the contract of employment and the fact that the employer was contractually obliged to provide an insurance scheme rather than to make the payments, this can be seen as a fact-specific conclusion. The EAT cited a number of cases where the employers had been less clear that they were providing insured benefits and they merely talked about providing benefits. So, if you're providing insured benefits, a clause indicating the employer does not take responsibility for the insurer's decision-making process, and which makes it clear that the benefits are subject to the terms of the relevant insurance policy, will always be a prudent statement. I think the employer was fortunate with the 2007 email, but that's pretty fact-specific, so I think it's difficult to draw conclusions about that in general terms. Where I think I do struggle, though, is the suggestion that because the insurance scheme contractually did not provide for benefits beyond 60, therefore it was not the employer's responsibility that, on direct age grounds, the claimant lost her benefits at age 60. There is, of course, a statutory defence for employers who stop benefits at age 65, so stopping a benefit at age 60 is clearly covered by the discrimination legislation in principle. I also don't think it is in reality any sort of an answer for an employer to say that the insurers chose the terms of the insurance schemes. The employer chose the insurers, so I don't think it can duck responsibility by simply pointing to the terms of the insurance scheme which it has purchased. It might be, although I don't think this was the flavour of the decision, that there was a real-world problem. Once the claimant was in receipt of benefits, no new insurers would insure her in respect of a continuing claim. So it would be entirely possible to defend the claim of potential discrimination on the grounds that there was no reasonable adjustment available because there was no insurance policy and no insurer in the world which would have insured her between 60 and 65 because she had an ongoing claim at the point when the employer was looking at extending insurance benefits generally to age 65. If that's right, and I emphasise that's not the way the decision reads, that there might then be a significant distinction between someone who is not in receipt of benefits and gets to age 60 and loses the benefit, and someone who is already receiving benefits at the point at which an insurance scheme changes. In short, I think it would be pretty risky to rely on this case as authority for the fact that an employer is absolved of its responsibility for its choice of insurance scheme if the scheme removed benefits on explicit age grounds for employees aged under 65. So that's the case of Smith and Gartner, and I suppose it'd be interesting. There must be a chance it might go further. Who knows? So the next case is Peninsula Business Services and Donaldson. This is an EAT case concerning whether it was discriminatory for an employer to make it a condition of entry into its childcare voucher scheme for employees to agree that such vouchers would be suspended during any period of maternity leave. So they had a scheme, but if you wanted to go into the scheme, you had to agree you did not get the vouchers during any period of maternity leave. Well, the facts are pretty straightforward. There is a childcare voucher scheme. Employers had to agree. Ms. Donaldson, who was pregnant, refused to enter into the scheme because she disapproved of the basis, and she challenged and said the scheme was discriminatory. Legal background? Well, Regulation 9 of the Maternity and Parental Leave Regulations, 1999, provides that employees on maternity leave are entitled to the benefit of all of their terms and conditions of employment, with the exception of terms and conditions about, quote, remuneration, unquote. This is because when an employee is on maternity leave, they're entitled to statutory maternity pay and potentially sometimes company-enhanced maternity as well. And so the statutory position is that all of their other remuneration will be suspended during this period. However, as I mentioned above, benefits that don't come within the definition of remuneration must continue to be paid during maternity leave. So, key question in this case is whether the childcare vouchers which were provided by way of a salary sacrifice scheme fell within the definition of remuneration under the 99 regulations, and as such, if they were remuneration, Peninsula could suspend these during Ms. Donaldson's maternity leave. It's important to note that the HMRC guideline states that childcare vouchers should continue during maternity leave because HMRC take the view they're not remuneration, they're a non-cash benefit. The HMRC guidance doesn't make any distinction between whether the childcare voucher scheme is being funded via salary sacrifice or not. Well, Ms. Donaldson brings her case to the Employment Tribunal, and the Tribunal agree, hold it is discriminatory for PBS to operate a scheme on such terms. In coming to its decision, the Tribunal refers to HMRC guidance and takes that into account. Peninsula appealed to the AT. Well, the EAT overturned the Tribunal's decision and find that childcare vouchers that are provided under a salary sacrifice arrangement are remuneration, and therefore benefit from the exemption in Regulation 9 of the 1999 regs. They don't have to be provided during maternity leave. In reaching its decision, the EAT took the view that HMRC's guidance was incorrect. Well, pausing there, it's important to highlight the fact that in the present case, the childcare vouchers were provided via salary sacrifice because this was crucial to the EAT's decision. EAT made it clear that if an employee is entitled to receive childcare vouchers in addition to their salary, these vouchers would need to be provided during maternity leave. This is because the vouchers are an added extra and couldn't be considered to form part of the employee's remuneration. The EAT acknowledged that there were policy reasons behind its decision, namely that in the context of a salary sacrifice scheme, by requiring employers to continue to provide childcare vouchers during maternity leave, this would provide a windfall benefit for the employee and impose an additional cost on the employer at a time when there is no salary that can be sacrificed. The EAT concluded this could not have been intended by Parliament. Also, the EAT mentioned that reaching the opposite conclusion and upholding Ms. Donaldson's claim would have the consequence of discouraging small or medium employers from providing salary sacrifice benefits to employees at all, because it would cost more than if they weren't providing salary sacrifice benefits. At first, this looks like an eminently sensible decision. It seems unfair if an employee who's opted for childcare vouchers was receiving, in effect, higher pay during maternity in comparison with one who'd opted not to do the salary sacrifice but had instead opted to retain her full salary. It's difficult to argue with a policy statement by the EAT that they think that small and medium-sized employers might be put off entering such arrangements. However, I think there are anomalies however you look at it. The one which we've come across relates to car benefits and car allowance. If you provide a company car, then you need to carry on providing that. The car allowance, well, maybe that's remuneration. Salary sacrifice operates as an amendment to salary, and employees' benefits and individuals' benefits are calculated on their lower salary. You give up the right to that higher salary. Maternity pay will be calculated on the lower salary. Arguably then the employee is losing out if she cannot claim the childcare vouchers for which she has sacrificed salary. The EAT do say they are relatively tentative in their conclusions, although I think on a proper reading that's because there were some jurisdictional issues which the EAT had to grapple with and which I've not gone into in this podcast. In addition, the claimant was representing herself, and the EAT commented, I think, around the jurisdictional issues, it may not have heard all the necessary arguments. So, turning now to whether it be sensible for employers to withdraw childcare vouchers during maternity leave, you also have to question this would follow even if this case is right. If employers have said to employees generally that childcare vouchers will be continued during maternity, then it may be a breach of contract to withdraw those childcare vouchers now in reliance on this case. Equally, the amount of financial savings may be so limited it's not really worth the demotivational impact it may have. It's also important to mention one other recent development in this area, which came in the form of the budget announcement a couple of weeks back. It was announced that childcare voucher schemes will be closed to new entrants from April 2018. Existing members at that date will still be able to continue to receive childcare vouchers, but only for so long as their employer chooses to continue to operate such a scheme. As such, we may soon see a fall in the number of employers that operate childcare voucher schemes, and therefore any uncertainty in this area may have relatively limited impact. So that's Peninsula Business Services and Donaldson. So third and final case, Hills and Nixon Inc. And I should just say that Nixon is spelt Niksun, Nixon Inc. So third and final case, dealing with a claim for breach of contract in relation to non-payment of commission due to the claimant by his employer. The Court of Appeal case concerns the High Court's involvement with an employer's assessment of the employee's entitlement to commission. And as I mentioned at the start of this podcast episode, the case produced a difference of opinion within the employment group here at Mayer Brown. To give you just the brief facts, the claimant, Mr. Hill, employed by Nixon as a regional sales manager. He had a bonus scheme which appeared to be set out in discretionary terms. Come back to that. He was paid 48% commission in respect of a piece of work, claimed it should have been paid 100%, and that he was owed the underpaid commission. On one view, the precise terms used in interpreting and in the scheme itself were key. Contract of employment contained a normal clause saying that eligibility to participate in, and indeed the establishment of a bonus scheme, was in the absolute discretion of the employer. Nixon did set up a scheme, and in 2011, Mr. Hills received a letter setting out the establishment of the scheme, which said, quote, all disputes in compensation and commissions, and in any interpretations of this letter or Nixon's policies, will be solely decided by Nixon management. The plan itself said, quote, this plan is not a contract between Nixon and its employees, does not confer any reasonable expectation of a particular amount or level of incentive compensation. Nixon reserves the right to determine what level of incentive compensation, if any, is fair and reasonable under the circumstances, and is in the best interest of Nixon. Until Nixon has made such a final determination, no portion of this incentive compensation shall be considered as vested in or earned by the employee. Unquote. Well, pausing there, I'm sure many of us have seen similar clauses in our time. The plan then went to talking about commissions being earned on shipments, paid, collections. Commission credits could be split between plan participants. Orders booked to an end user will be credited using 100% going to the, quote, point of influence, unquote. So, usual, if I put it this way, boilerplate, massive discretion, and then some fine detail around how commission is calculated, earned and split. In these types of cases, one of the factors the court will look at when coming to its decision is whether the employer has exercised discretion in a perverse or irrational way. Here, the grounds of appeal by the employer were that the High Court had erred in instead looking at the employer's thought process behind the decision to award a bonus, and Nixon was contending that it didn't need to give evidence about in view of the discretion that it had. Well, the High Court decided that a 48% allocation was not fair and reasonable in the claimant's circumstances, and that any amount less than 2/3 payment to Mr. Hills would fall outside the bracket of what could be considered fair and reasonable. Nixon had argued in the High Court, They have a broad discretion when it came to deciding the level of the commission, but the High Court disagreed, concluding that the bonus plan had a detailed process for the award of commission, which Nixon was obliged to follow, and so this meant that Nixon's discretion was not broad and untrammelled. Crucially, as I say, at the High Court, the employer did not lead evidence from the person who actually made the decision to award the 48% split to Mr. Hills. Nixon appealed to the Court of Appeal. The employer argued the High Court had substituted its own views as to reasonableness for that of the employer. Nixon claimed the High Court had been wrong to decide that a higher commission should have been paid, and that unless Nixon's decision, and they said that unless their decision in awarding 48% commission was irrational, the Court had been wrong to interfere with the allocation. Well, the Court of Appeal dismissed the appeal. They decided the High Court had been entitled to decide as it had in relation to the level of commission. The Court of Appeal confirmed that the High Court's determination that 48% was not a reasonable figure for the purpose of calculating how commission should be split between regions was correct, and in fact the two-thirds figure was reasonable. Regarding the claim that the High Court had substituted the employer's thinking with its own, the Court of Appeal held that Nixon had not presented any evidence of its decision-making process. Therefore, it could not be assumed it had made a reasonable decision. As such, the Court of Appeal held that the High Court had been entitled to come to its conclusion. The Court of Appeal rejected the argument that the High Court had failed to have regard to Nixon's interests. If you remember, that wording in the plan rules talked about in the interests of Nixon, and they said that had been adequately covered. Well, this case follows on from the case of Braganza, which we looked at in podcast 73, nearly a year ago now. And employers need to bear in mind that once an employee has established an employer's exercise of discretion may be irrational, it's then for the employer to show it acted reasonably. So why do I think this case is more significant than some? Well, first, the Court of Appeal talk about the burden of proof point. The Court of Appeal say that the burden of proof requires the claimant, the employee, to show, quote, there were grounds for thinking that Nixon's decision was not reasonable, unquote, not reasonable, note, and then, quote, the evidential burden shifted to Nixon to show that its decision was reasonable, unquote. They assert this is in reliance on Braganza. A burden of proof which requires the employer to show its decision is reasonable would be a significant step. Secondly, Nixon's general wording on the bonus expressly gave it the right to determine any disputes at its discretion and the right to determine what level of incentive compensation is, quote, fair and reasonable under the circumstances and is in the best interests of Nixon, unquote. Instead, the Court of Appeal seemed to proceed on the basis that becomes a commitment to making a payment that is fair and reasonable, pointing to this, but not taking into account and in the interests of Nixon. It's just about possible to argue the employer could have been even more specific that the plan and all aspects of it remain completely discretionary, voluntary, etc., etc. However, the Court of Appeal justify their findings on the basis there was not a, quote, general discretion such as is found in the bank bonus cases, unquote. So I think the true significance of this case is in emphasising that if you intend to include a clause giving you a general discretion as to what payments get made, if any, but are also including some detailed guidelines, you have to be very, very clear, because the court will go as far as it possibly can to allow employees to challenge something that is seen to be unreasonable, not irrational. This is where it's a particular problem, because on the one hand, the employer wants to motivate employees by showing them in general terms how they can earn bonus, while on the other hand, wishing to reserve a broad right for the employer to assess that level of bonus. Clearly, it would have been easier if they'd been able to lead evidence in this case as to why the decision had been what it was. But the employer's point of response is that it should not have had to do this if it had retained a complete and absolute discretion as to what payments, if any, got made. So, that's the case of Hills and Nixon. So thank you very much for listening, as always. I apologise. This podcast, of course, is going out a few days later than normal because of Good Friday. We tried to put the podcast together and actually get it recorded and out before the Easter break, but it didn't happen. So I hope everyone had a good Easter break, and we'll be back slightly earlier within the next 2 weeks with episode number 91. And I think apart from that, it only remains for me to confirm that, as always, no employees were harmed or mistreated in the making of this podcast. Thank you very much.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.